So I'm Matthew over here, and today we're going to be talking about wills. And when we talk about wills, a couple things to keep in mind. One is wills are governed by jurisdiction. So in Canada, they're governed by each individual province. So there'll be slight variations in them. We're talking about some of our international viewers who have commented in the past. Again, in states, it's going to be governed by each individual state. Will have their own kind of guidelines and rules about how estates work and how wills work. And so it's going to vary across the internet and how this actually happens, or how this actually gets decided by a court, or how things are interpreted, or what the proper rules are. But generally speaking, there are two types of wills. One is called a holographic will. And a holographic will is the one that you see in the movies, the people handwriting it out, they sign it, they date it themselves, it's not witnessed, it's hidden in a drawer, and someone finds after someone passes away. A formal will, it tends to be typed out, it has two witnesses on it, they've initialed every page, it's dated, the testator has signed it, and then that's the one that, people go to the lawyer's office for, or notaries, and that's when they get prepared there. The will that we're going to look through today is just to kind of give people an idea of, well, this is what's in a will, and this is some of what these terms mean. And so when you go and you're preparing your own will, you have a better idea of, like, this is the interpretation. When you watch this video and you're like, oh, well, I want something more, or I didn't understand this, or I'm thinking of something else that should be added to this, then that probably means that you need something beyond just a simplest will. You probably need to go and talk to a lawyer or notary or someone who prepares wills, and they'll be able to answer your questions more in full. As always, everything that we provide here is not independent legal advice. If you do have legal questions, ask a lawyer. They'll be able to help you out. All right, so we're going through the will. What we have is, you start off with who is actually making the will. This is the name of the person. We're using the infamous Dunphy family. We're out of Alberta, Canada, so again, this is where they're from. The person is putting their names. You can also put addresses, phone numbers. The point of that is identifying the individual. The first step that you know of when you create a will is you should only have one will. And that one will replaces all other wills. And this avoids conflicts between your beneficiaries. It creates clarity as to what you want your last wishes to be. And so first step should always be, this will revokes all previous wills. So anything dated before this date would be null and void. The second thing that wills tend to do is they appoint who's going to be the one that actually administers that will. It's called an executor. And executors can either be one person, and then you have an alternate. They can be joint, so you can have multiple people acting as an executor. And in this case, appoints their child, Alex Dunphy. And then if Alex Dunphy is unable to do so, or he predeceases you, then appoints the other son, Luke Dunphy, or child. And then they get referred to again in the context of Alberta as a trustee. The other thing too, as I said, is if people's names, for example, are John Smith, and that just happens to be your name, there could be reasons because of the more common name to put things like the city or address of where they're from, or a phone number after you name it, executor or a beneficiary as we go through the will, to make it more clearly identifiable who that person is and where they're located at the time of the will. And that will help the executor better identify where that person is, especially if that executor isn't a person that you know of. So survivors, to kind of take away from the conflict of parties where, say your whole family crashes in an airplane accident while you're on vacation, but one of those people, dies on impact, one of them, survives for 5 hours, someone is in a coma, they survive for 2 weeks, and we put in this survivor clause to basically say if they all predecease within this period of time, then they're considered deceased for the purpose of the will, and so they wouldn't become a beneficiary, or they wouldn't be able to be an executor, etc. What this does is, particularly when you think about blended families, so people have multiple children from separate relationships and then they get together, it reduces conflict. So you know which will takes precedence and who is actually going to be a beneficiary under the wills, and how they get triggered. Without this, what happens is people can fight over, oh, well, this person died first or this person died first, and they might have a complete argument. Oh, well, this person was in row 5C. The plane went down like this, so they obviously died first before the person who was in 19C. Again, complicated, stressful, and not fun, easily correctable by a single sentence. Guardian. So really important to know, typically guardians under will says, okay, if I have minor children, this is the person that's going to be, that I'm recommending to be appointed to be the guardians of those children. A couple things to keep in mind. If you're married or separated and you have a parenting order that says this other person is going to be a guardian, that person likely has a higher priority depending on your jurisdiction. So again, mom and dad are separated, mom passes away, kids are likely going to go with dad. Putting something like guardian into there, though, does, by circumstance, give that person an ability to say, well, look, I'm trying to follow the will of the people. If dad says, no, I can't take them, because, for example, dad works away, he has a sales job and he's traveling all over the country, it also gives whoever's appointed as guardian the ability to step into that role much easier. So that's one of the reasons why you would include it there. And same thing, you can have a guardian, and then you can have an alternate if that person isn't available. Similar to when we talk about family law matters, where there could be child support. One of the things when you have minor children and a parent passes away is their estate can be used to help pay for some of those costs, such as clothing, food, education, buying a vehicle, that sort of stuff. And so they can encroach upon the estate for that, separate from what the will says. And again, it's going to vary quite widely by jurisdiction. Organization is something I'm seeing much more common. Just the idea that in your will you can say, my organs can be donated, or my body could be donated to be a cadaver for science at a medical thing, and that's always in high demand. Funeral instructions, again, are very common. It's really important. The executor has to follow your funeral instructions so long as those funeral instructions are legal. So if it's, hi, I want my remains to be cremated, then you're fine. However, if it's, hi, I want my remains to be cremated and then my ashes dispersed at a lake, typically dispersing ashes is in violation of many environmental protection regulations, and so they don't necessarily have to follow that particular part. You kind of put that into your will. They may do that, and I've had all sorts of things because different people have, different attachments to different geographical areas. But just know that it's not going to be binding on them if the act's illegal. And if you're trying to administer a will, know that as well. So then disposition of estate. And here's a really important part to think about when you're looking at, okay, how is my estate actually going to be distributed to? First, just as in a bankruptcy or selling a business, first thing you have to do is pay off all your debts. So any debts owed by the estate, big one being taxes, those all get paid first. Typically speaking, registered, so retirement savings plans and life insurance policies are contractual, and they trigger at time of death to go to that beneficiary. So those funds, as long as you have named beneficiaries in those types of accounts or with those types of life insurance policies, they don't actually enter into the estate. So what that provides you with is an enhanced tool to plan around your estate, because you can then just, instead of having to redo your will, you can meet up with your financial provider and change the beneficiary percentages on those types of investments or on one account. Common ones I also see are things like TFSAs, so tax-free savings accounts also have that as well. But mostly, again, life insurance policies and RSPs are the two most common. If you do not have a named beneficiary, they just become residue of the estate. Specific bequests. So specific bequests are basically items that are going to a very specific person. So again, in this particular case, Alex is getting Billy the dog, and Alex is getting the jewelry for their own use, absolutely. So prior to anything else going from the estate, prior to any other money getting dispersed outside of those debt amounts, Alex gets these items. And you can use specific bequests quite a bit to, provide things of value to individuals. Common ones that I see in Canada, because we have our firearm licensing system, is you have to have a PAL in order to do a transfer in between people. So often I'll say, if you're going to do a specific bequest and you have firearms and your spouse doesn't have a PAL, bequest them to someone who does. It'll make their life a lot easier. Then you don't have to go and do transfer paperwork or things like that. Jewelries are also very common. Again, things like family heirlooms get transferred down or passed down that way. So that's another very common one. And then things that have value, sometimes I'll see things like record collections or stamp collections, coin collections, that sort of thing be included there as well. A lot of times you'll see a clause, and again, see this written in many, many different ways, but what it really is basically saying that if my beneficiaries survive me and they agree on personal effects and where those go, then they don't enter the estate. So these pictures can, if you have the two children as we're growing up here, Alex and Luke, and Alex and Luke agree that Alex can have the photo albums and Luke's going to take some of the pictures off the wall. So if they agree, they just don't enter into the estate, so they don't have to be accounted for. And then everything that is disagreed on, then it typically gets sold. It goes to auction. A lot of things don't have value when people pass away. 25-year-old couches, that sort of thing. It just gets taken to the dump or to the reuse center, something like that. So then memorandum regarding personal effects. So this is something else, again, that I recommend that people do, and not very many people do it. And what it basically is an attachment to the back of your will that you're saying, okay, I want these items to go to these people. And typically those items are sentimental in value, not actually quantifiable. So things like, I want my pasta maker to go to this niece because we made pasta together and I think she'll really enjoy it. Or I want my china, which doesn't have a whole lot of economic value, but it, is sentimental value because it was, great grandpa's. And I want it to go to this person because they expressed an interest in having it previously. So you can write that and attach it to the will. The trustee, again, is just a line to the trustee to follow that memorandum of those things. But there's a degree of, within the will, it's you must do this, and within the memorandum, it's I want you to do this. And so the degree of onus on that trustee to find those things and match those things up is a little bit less. So typically they are required to try to do it, but if they can't find that person, then it tends to be more agreeable for them to, on that memorandum, to find another solution to those items. That is much different than the specific bequests up here where the trustee has to provide those items to those individuals. And then finally, disposition of residue. So after all those specific requests, all the debts are paid, dealt with RSPs, dealt with, everything that other people wants, is what's left gets split up. So in this particular context, Alex and Luke, being the two children, get equal shares, so that would be 50-50. When we look at this, it can be, one of the things I tend to recommend to people is put specific names in to wills. If you just leave it as between my children, and then all of a sudden there's an adopted child, or all of a sudden there's a biological child that someone didn't know about that pops up, that can encompass them within that general definition of what a child is. So by putting specific names in, you've closed that class of people into there. The other thing that I'd recommend, and that isn't in the will here, is particularly setting out, here's what the share amounts are. So 25% to Alex, 25% to Luke, 25% to whoever. Right, and obviously in this case, 50%. Again, it's more specific, and it becomes more clear than just having it as equally. And when you're looking at multiple beneficiaries, so you maybe have 7 people that you're providing a beneficiary to, having that breakdown makes it a little bit more clear. They're not fighting over the half percentage that's left because it's not, equal, identical. So something to think about there. Alternate disposition of revenue, just like when we're talking about who's the executor, who's the guardian, you can then break this down as much as you want. So if, say, Alex and Luke are in the same plane accident, so they've passed away, okay, in the event of a child of mine predeceases me before becoming entitled, then any children that they have would be entitled to their share. And so again, this is a very common solution. So again, if Alex had 2 children, Alex predeceased the testator, then what would happen is his share could go to his 2 children. So if he had 2 children, then it would be child A would be 25%, child B would be 25%, and Luke would be 50%. If they didn't have any children, then it would go to the surviving children. So if Luke passed away, he didn't have any children, then Alex would get 100%. Something else that people add to the end, it's not again in this particular will, but I just mentioned it, is I call it like an act of God or a natural disaster clause. Everyone in the will passed away. See my airplane thing. You can put, if everyone provided to this type of charity or organization, which will likely still be alive. Again, this prevents infighting between my 4th cousin who finds out about this and is now applying as the closest relative for a portion of the estate. And then all the other fourth cousins jump in, right? And so putting something like that in that says, okay, well, I want everything to go to the, St. Jude's Children's Hospital or the Breast Cancer Foundation can help remedy again and deter conflict. Trust age. So again, in that case where it was going to children who are under the age of 18, you can set certain trust ages. And those trust ages, so we're clear, it does not have to be 18. It can be 21, it can be 23, it can be 25. And I've seen a mix, so 25% at age of 18, 25% at 21, and 25% at 23, 25% at 27. The whole point of it is to spread out especially if there's a larger estate amount, over a period of time, so they don't have access to those funds as they're growing older. As you can imagine, providing an 18-year-old with a large amount of money tends to be, from a parent's perspective, not the greatest of ideas. They'd rather spread it over time so that as that person hits certain life goals, going to university or college or, buying a new car. I've seen some of them say, okay, release, 16 when they can get a driver's license, for example, we'll release this much to them at that point as well. So it can be under as well. And for specific purposes, or, if they attend, college, this much can be provided to them for college. So you can build those things into the trust age. And you do have a little bit of control within your estate to assign those things, so long as they're achievable, they're not illegal, and so many people do. And our last part is kind of the general provisions. And so these are the powers of the trustee. So that's the executor who's dealing with the will. And so again, gives them the ability to realize on the estate and to collect funds and put funds into bank accounts and sell things and convert things into cash. Retain any assets and deal with them as they so wish and what they think is the best for them. Pay funds to a guardian, as we talked about, pay taxes, distribute assets to the particular beneficiaries as needed. Employ a corporate trustee. So sometimes, particularly if people have companies or complex investment portfolios, there might be reasons why they'd actually hire someone else to do that. Dealing with real property. So one of the reasons where you have to actually go through a process in dealing with a will, going to probate, is to deal with real property. And so again, be able to hire people to realtors to be able to rent out the property if they think that it's a bad selling market, but they can rent it out to cover its costs. Those are all things that the trustee has the power to do. Same thing again, invest money. So instead of distributing it, if they're waiting, they can say put money into a investment vehicle like a savings bond or a GIC, etc., etc. Big thing is, as a trustee, they can't invest it into, and I certainly wouldn't recommend it, into something that's going to be risky. They have to justify why that investment is, and the trustee has to act in the best interest of the beneficiaries, even if they're wearing multiple hats. And so where sometimes I see trustees and beneficiaries be in conflict is the beneficiary puts it into a low risk but low interest investment while they're waiting for probate or while they're waiting for the house to sell or something like that. And beneficiaries say, well, why don't you put it into a higher one, because it can earn a higher rate of return? And the reason being is the trustee, the trustee/executor does not want to get into any trouble by the amount going down, right? Because then someone says, oh, you lost this money. That's why. So again, low risk makes it a little bit easier to deal with. And then if there is a business, trustee can carry on that business, deal with that business, get it ready for sale if that's what the plan is. Again, depending on what the will says, and deal with any contracts in relation to that business, employees, etc. So then we're almost at the signing page. So capitalization of income, let's talk about that quickly. It just says that because certain things earn interest income, that interest income can then be paid to the portion of the beneficiary that they have as capital. So if it earned $1,000 as interest income on an investment, that interest income can then be assigned to the 50% interest for each party, so $500 each that the beneficiaries receive. This can also be modified, by the way, and I see it quite often changed when they're, again, older spouses in wills, where it'll say that capitalization can go to the maintenance of a particular home if a spouse is going to be living there or something like that. So an alternative way of dealing with that interest income that might have from investments. Again, executor signs, so Claire's signing here, and then two witnesses. So we've got Harry Dunn and Lloyd Christmas, both signing off as witnesses. Their addresses, occupations. Again, that's just to identify who they are and who those witnesses are in case there's a dispute in the future. Oftentimes, too, again, just depends on jurisdiction. There might be some form of affidavit or statutory declaration that one of the witnesses signs saying that they swear that they saw the testator sign the will, or testatrix in this case, sign the will. And and the last thing I mentioned is both witnesses and the testator have to initial all of the pages. And that just proves that, people can't insert things into those pages. And there's only one original. So you can put a copy, but you want to make sure that you write copy over this whole thing. And you're much better off just keeping one original. Oftentimes, lawyers will have a will safe, so a fireproof safe that they'll put these in. But if you're going to be keeping it at home, obviously you want to keep it in a place that isn't going to have water damage or fire damage to it. So again, a safe. A lot of people have safety deposit boxes, so storing in a safety deposit box also makes sense as well. So this kind of gives you a general idea of what a will is and what some simple terms are in a will and what those correspond to. To take a look at some of our other videos, we're going to be talking about personal directives / living wills and enduring power of attorneys, which deal with things when people lose capacity but they're still alive. And so a lot of times, again, people are in accidents, they go into comas, or people, as they get older, they get certain mental infirmities such as Alzheimer's, dementia, which are really the same, similar things of the same horrible disease. Those will kick in there at that point, and allows people to deal with this people's assets and deal with their personal decisions while they're alive. So check out those videos later on. If you found this video helpful, please like, comment, and subscribe below if you'd like to see more content of similar nature.